Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us. Today we're going to be taking questions from viewers on debt relief. And joining me as always is my co-host Jesse Barrientos. Jesse, welcome to the show.
Thank you, Dave.
How are you doing today, Jesse?
I'm doing excellent. It looks like our viewers have lots and lots of questions.
Yeah, we do get a lot of questions over the months, and a lot of them have to do with debt relief because they know that that's a topic that we cover. And especially now, Jesse, things are really getting tough in the country. Between the housing market towards the bottom, the jobs, I don't know where the jobs are, but they're gone. Escalating prices for gas, food, utilities, postage, you name it. Everything is through the roof except for wages. People just got hit with a 2% decrease thanks to the payroll tax increase. So things are really tough in this country, and I'm not surprised we're getting so many questions at questions@legalactiontv.com, or you can also go to the website, legalactiontv.com.
And there's a lot of questions that are duplicative or very, very similar. So people out there are having similar issues.
Absolutely. Let's kick it off. I've got Carlos in Waukegan, Jesse, wants to know how much is it to file a Chapter 7 or a Chapter 13?
Well, they're two different. It depends on the attorney that you go to. The filing fee for Chapter 7, I believe, is $306. And I believe for Chapter 13, I want to say $287. $281. Well, we round up just a little bit. And the attorney's fees can range really anywhere from, $900 to $1,500. It just really depends. And quite honestly, even in a Chapter 7, if you have an enormous amount of creditors, there's a whole lot more work to do. And so if you have more, it stands to reason that, that fee should be a little bit better.
Yeah, isn't it true, though, that an attorney is going to charge in a Chapter 7 based on their value, what they bring to the table in terms of experience and knowledge, and you often do get what you pay for sometimes with quality representation.
Exactly. I was just, this is one of the few cases where I was representing a creditor, and at a 341 meeting, which is a meeting of creditors, you're entitled to go in and to inquire of the debtor in terms of their schedules, and they didn't have schedules A, B, or C, which is their schedule of real estate, schedule of exemptions. And
did the trustee hold the meeting with incomplete documents?
No, absolutely did not. And in fact, I checked not too long ago, and the trustee had rescheduled the meeting, but had also filed a motion to dismiss.
Yeah, that's good.
So again, when I say that to say that, hey, that's a no-brainer. Obviously, that's the heart of what your petition is. Trustee isn't even going to be able to determine if there's any assets or what the exemptions are, what your personal property is. I mean, you could have $1 million in real estate, or you could have $1 million in personal property, and if you don't have those schedules, which are attested to, he's not going to be able to do it. So,
was there an attorney involved in that case on behalf of the debtor?
Oh, yes, the attorney filed it, and that's kind of what surprised me. But hey. Okay. Could have been a stalling tactic, who knows? Or it could just simply be inadvertence or a mistake, or, could be incompetence, who knows?
Absolutely.
Yeah. But anyway, so it really depends. In a Chapter 13, generally, in addition to 281, I believe the statutory fees are $3,500. And so most of that, though, is going to be paid throughout the course of the plan, so 36 to 60 months. And then it's going to really cover pretty much anything. Sometimes the plan might have to be adjusted. Sometimes there might be other motions from some of the creditors, and it's typically going to include that. It might be over if there are extraordinary motions or something that is not foreseeable or something that is not ordinary. Then that might encompass an additional fee. But generally, that's what it's going to be.
Well, since the standard fee in a Chapter 13 under the model retention agreement is $3,500 over the life of the case, and I would say 95% or more of the Chapter 13 attorneys opt to take that flat fee as opposed to being able to bill hourly, I think it's incumbent upon the debtor to really make sure that they're hiring good counsel, because they're going to be paying the same $3,500
to anybody,
to a good attorney or a lesser attorney.
That's true.
You want to make sure that that person files Chapter 13 cases on a daily basis, works on Chapter 13 on a daily basis, and understands how it works, because it's a much more complicated case than a simple Chapter 7.
Right. True enough.
Very important.
It's just like anything else. It pays to be informed and advise, do some research, look on the internet, talk to some friends or perhaps, and it's not going to hurt you to see a couple people. A lot of times folks will have free consultations, but I'm going to tell you, if you're going in for a free consultation, fill out the form.
Right.
That's the only way they're going to know.
Yeah, I want to caution our viewers to be careful about reviews they see online too. Don't just read one review or two reviews. Look at the reviews in their entirety. And I'll tell you why. There's a review about me from a client who I never represented. It's a fake name, it's a fake city, and at the end of the review, this person touts about another bankruptcy attorney that everybody should go to. So it's obviously bogus. So look at the reviews in their totality. Don't rely on one or two. Very important. Anybody can say anything on the internet these days, and a lot of it's false.
You mean if it's not on the internet, it's true? Or it's not true? I didn't think
Something
they could put
like
anything
that.
that wasn't true on the internet.
Yeah, right.
All right, Dave. Carrie from Mount Prospect. And this is a question that we've had, actually a few in our other show, our other question show. It says, my car was auctioned 4 months ago. Can the debt be eliminated, or would I have to pay?
If the car was auctioned, that means it's gone. Someone has already taken ownership of it from you. So the auction is much like a sale date with real estate. Once it's auctioned off, it cannot be recovered. The car rightfully belongs to someone else. If, however, you can get a hold of a filing before the car is auctioned, you do have the ability to get it back under Chapter 13. There's a Supreme Court case called Thompson, which basically says the vehicle is still yours because it hasn't been sold, and if you have the ability to reorganize it under Chapter 13, they must give it back. Of course, if you don't make your payments, they can ask for the court's permission to just repo it and sell it again, but as long as it hasn't been sold, you can get it back into Chapter 13 under the Thompson case and repay that vehicle debt over time.
That seems like that's a situation that's prime for abuse.
Well, the creditors do have a remedy, though. If you get the car back because you filed a 13 and you don't make your payments, the creditor can immediately come in on a motion to modify the stay and get the vehicle back. So what are you buying, a week or two? If you can't make your payments, you're going to lose the car.
They're going to have to go back in and repossess it and start from the beginning, are they not?
They are.
Or is the bankruptcy court going to order them to immediately turn it over?
The bankruptcy court will immediately order them to turn it over if they haven't done so voluntarily. Because again, this Thompson case that I keep citing is a very critical case on the subject, basically says that vehicle belongs to the debtor until such time that it's sold. So if it hasn't been sold, the creditor must give it back. They shouldn't wait for the court to order them to give it back because they could be sanctioned for that. So if you have a vehicle that's been repossessed and it's not yet sold, you have rights.
True enough.
So contact an experienced bankruptcy attorney to find out if Chapter 13 is a good avenue for you. Or you might just let the vehicle go and do a Chapter 7 and get a fresh start and get a new vehicle or a used vehicle.
Especially if you're upside down.
Absolutely. It's a good way to get a fresh start, take a bad situation, get back to a level playing field, get into a car that you can afford. Even if it's a used car at CarMax, make sure it's certified.
Or even a lease, a cheap lease, you can, depending upon your amount of driving.
Depending on what kind of lease you can afford. Yeah, that's a good idea. I've got Brent from Northbrook. Can you file my bankruptcy case before I pay you in full?
Well, here, Brent, let me tell you, that's dependent too. If it's a Chapter 13, we can. You're going to have to pay the filing fee, and you're going to have to pay some of the attorney fees up front, but most of it is going to be included throughout the plan. So that's not a problem. With respect to a Chapter 7, the issue that I always have is because it's going to be post-petition, so if I file it for you and you owe me the money and it's post-petition, then technically then I am a creditor who's subject to discharge, and it's an unsecured debt. Nobody's going to do that.
Yeah, unless you enter into a post-petition retainer whereby you itemize what kind of activity you're going to do before the case is filed and what type of activity you're going to do after. But you're still basically dependent upon the debtor to make voluntary payments, whether or not it's discharged or not. You can be out of luck and not be able to collect your fee.
Right, and you know what? Hey, you're going to be doing a lot of work for that, and I'm sorry, but I suppose there might be a case or so that might warrant it, but for the most part, you got to at least come up with that, because we're going to be saving you having to pay all of this, and generally you're going to be discharging thousands, $20,000, $30,000, $50,000 worth of debt, and not having to pay these monthly payments. And so, that's something that, hey, if you can't take care of right away, you know what? You might want to talk to mom or dad or do something in order to make that happen, especially if you have something like a garnishment hanging over your head.
Right, but the good news, the minute they hire you, they're going to get some level of protection because they can tell creditors about you and they have to go through you.
That's correct.
And unless there's some kind of court action, you are providing a good amount of protection,
Right.
even without a case being filed yet, correct?
Because they're not going to get. But again, the ultimate protection is when you file that case. But yes, the creditors are going to have to contact your attorney.
Yes.
Yeah. All right. We have Ted from Rosemont who says, "I'm 3 months behind on my mortgage. Do I still have time to save it?"
Well, if you're 3 months behind, you have plenty of time to save it. Under the Illinois mortgage foreclosure law, you have almost a year before a creditor can start the process and finish the process to remove you from your home. Now, there are some varying degrees on this, but for the most part, you have plenty of time. So you can do one of several things. You can let the house go and get out of debt. You can file a Chapter 7 and eliminate the debt. You can do a Chapter 13 and try and repay the part you fell behind over the next 3 to 5 years. And if you're only 3 months behind, that's going to be a very low payment, but you have to make your regular payment going forward as well. And the other option is you just defend the foreclosure and you stay in the property as long as you can. You make the mortgage company prove their case, knowing that you eventually are going to have to vacate the property and move on.
Well, what happens if I do that and I defend in the foreclosure case, and then after the foreclosure, say it is a negative disposition for me, can I then file a bankruptcy?
Sure, if you would otherwise qualify for Chapter 7, you can eliminate any kind of mortgage deficiency.
Or 13 at that
Or
point?
13 as well.
And is that going to give me some time, or what is that going to do?
Well, 13 is not going to give you any more time once it's gone to a sale and you're in a bad disposition, but you will be able to pay off any deficiency over time. But in most cases, if you've given up a house, you're more likely going to file a Chapter 7 and get a complete fresh start, and you'll also eliminate the tax liability from that mortgage as well.
You mentioned a word there, deficiency, and I just want to make sure that the people at home understand what it is. This is true with your house, and this is also true with the car. Let's take it with the car. If I owe $20,000 on the car and you repossess it and you sell it for $5,000, then the deficiency is $15,000 plus what it cost you to repossess it, plus the fees to sell it, plus more fees. Fee. Same is true with the house. All right. So if I owe X amount and you sell it for less than that, there's going to be deficiency. So with respect to the house,
well, here's the difference. And the vehicle is going to likely pursue the deficiency because that's their practice. They can do that.
Unless I file a Chapter 7.
Correct. As far as mortgages goes, the deficiency is not always sought by the lender, and it's not always granted by the court, even though the law provides for it. So many people who give up a house and relinquish it, either voluntarily or through the foreclosure process, don't always have a deficiency to deal with, even though they were upside down. Sometimes the lenders just let them go, and they don't pursue them. But you never really know until you go through the process. So an attorney can't say for certain whether there's going to be a deficiency or not. And if there is a deficiency, you still don't know if they're going to pursue it. Okay, you can have a deficiency on paper, but that doesn't mean they're going to actually pursue you and try and garnish your wages and attach bank accounts and otherwise try to collect.
True. And people should know there are a whole lot of programs out there. One, for example, is Cash for Keys, where a lender will work with you and will actually give you money for you to move as long as you turn it over and, basically give the house back. It's a deed in lieu of foreclosure. People also have an option to do what they call a short sale, which is trying to sell it, and the lender will approve an amount less than you owe. You may have to come to the table with some money or with no money, but you're certainly not going to get anything. Danger of that perhaps might be that whatever the difference is, you might get a similar form like a 1099, which you may be subject to those taxes. However, there are just a whole lot of options, but people need to go into an experienced attorney to be able to discuss those options with you.
Yeah, and actually at the time of this airing, in about a week, there's going to be an amendment to the HAMP program, which is the Home Affordable Modification Program, whereby homeowners can actually have a higher debt-to-income ratio and still qualify for what they call the Tier 2 HAMP. So what I'm getting at is there's more and more help available for homeowners at all income levels. Some of the restrictions are coming down, and more people, as we go through this foreclosure crisis process, are finding relief. So keep an open mind, stay optimistic. It really is true. The laws and the policies are changing over time to help more and more people stay in their home. Don't give up.
Don't give up. We're here to help you. I mean, what's the worst that can happen? You know, we'll give you some ideas and point you in the right direction, or might actually be able to do what you need to save your home or to do whatever. There's a Cliff from Chicago who says, if I file for bankruptcy, can I get my license back? Now, that's
Driver's
the question,
license.
right? But this is we want people to know kind of what it is. Generally, if somebody does not have liability insurance and they are involved in an accident and there's a judgment that's secured, they can lose their license until the judgment is paid, or even if they enter into some kind of an installment agreement with the plaintiff, the person that they hit.
So the suspension in this case is based on no insurance at the time of an accident.
Well, this is what I'm guessing. I mean, it just says, can I get, if I file for bankruptcy, can I get my license back? So that's kind of what I'm imagining it would be.
But you also can lose your license for parking tickets.
You can lose your license for
tollway violations.
You can lose your license for child support, but that's not going to happen for you. If it's for child support, I think you are out of luck.
Okay.
However, that's a whole other show, because you can go back into the court and, in order to generate income to be able to pay your deficiency amount. But, that may be a hard sell, may not. So, Dave, that's the question.
Well, if your license is suspended for insurance, like you said, if you file a Chapter 13 and repay the debt over time, your license can be reinstated. You can also do a Chapter 7 and eliminate the debt as long as it wasn't for personal injuries caused by DUI or other forms of intoxication, because, there's more to DUI than just alcohol, as you know.
There's drugs, prescription medication.
Right. You can be smoking marijuana and get pulled over, and that is going to be a non-dischargeable debt if you injure somebody while you are high on marijuana.
Even if you have a license for medical marijuana, which Illinois hasn't approved yet.
Right. Illinois we'll get there eventually. We're still working on concealed carry in Illinois. We're the only state in the union that doesn't have that. So we're a little bit behind around here. But anyway, you can get your license back under Chapter 13 if you can repay over the next 3 to 5 years. And most people do that because they need the license to get to work. A lot of people drive for a living, and those are the ones that call me and say, I need to get my license ASAP. I don't have the ability to make any income.
Right.
All right, Kevin from Wheeling. Jesse, can I keep one of my credit cards and not put it in the bankruptcy? He's got a favorite credit card he wants to keep.
No. Well, actually, you can if it has a zero balance, but let me tell you what's going to happen. Okay, a lot of these credit card companies are plugged in and they know what's going on, and once they learn that you file for bankruptcy, I mean, it's going to be all over. But not to worry. After you file that bankruptcy, you're going to get tons and tons of mail for you to get another credit card.
How so? Why would that be?
Well, that would be because you're not going to be able to, if it's Chapter 7, you're not going to be able to file again for another 8 years and a day, and so that makes you a little bit better of a credit risk. Also, what's going to happen is they're going to extend to you a lesser amount of money at a much higher interest rate. And so that's what you're going to get. Unfortunately, you can't keep it. If you owe money on a credit card, you have to include it in your voluntary petition for bankruptcy. You have to include all of your assets and all of your debts.
So immediately after a bankruptcy filing, the advantage flows towards the credit card issuer.
I would think so, because then you have more protection, because that person, if it's Chapter 7, they're not going to be able to file a Chapter 7 for 8 years and a day. Now, they can file a Chapter 13, and I believe if they file a Chapter 13, I think it's within 2 years of a Chapter 7, they have to pay back 100%, if I'm not mistaken. I think it's 2 years, right?
Or they can't receive a discharge.
Right.
But in Kevin's case here on this credit card, it says he owes $750 on the credit card, and he was thinking of continuing to pay that, even though he's going to eliminate about $60,000 of other credit cards.
Bad idea, because they're just going to cut them off anyway. It's an unsecured debt, and you know what? That $750 could go toward the attorney's fee. He would be that much closer on his way. It's just not going to happen. I get a lot of people that come in and, for example, they have the dentist or the eye doctor that they've seen all of their lives, and they owe a couple $100, and I tell them, well, then fine. You know what? You could pay for it before you come in, or after bankruptcy, even though the debt's discharged, do whatever you want if you want to. You don't have to, but you certainly can.
Right, and most medical providers understand that there's a reason why someone had a file.
That's true.
And plus, any ongoing service is going to be non-dischargeable, so the medical provider understands that anything going forward, they're going to likely get paid on. So,
Yeah, yeah,
So they should be willing to keep that person as a patient.
they should, absolutely. All right, we've got, it looks like Alex from Wheaton. This is a good question. It really is, because associations are different. It says, can I put my association fees in the bankruptcy?
Well, it's going to depend on what type of bankruptcy you file again. If you're doing a Chapter 7 and you're trying to eliminate the debt, then the fees can be eliminated, but you're not going to be able to keep that condo going forward because there's going to be a lien against it, and they can do an eviction for any post-petition fees. In a Chapter 13, this is where we see it more often.
Go back a little bit.
Sure.
So what you're saying is, if I owe the association, $2,000, now I file for bankruptcy, right? That can be eliminated
Well, there's a lien still. So if you try and transfer the property, that debt needs to be paid.
because it runs with the property.
Right.
Unless it's a Chapter 13.
Correct. There's no personal liability if you do a Chapter 7.
But if I'm walking away from it, it really doesn't matter.
Correct, with one caveat. You are on the hook, technically, for association fees for as long as you own that property. So even though you walk away from the property, let's say you vacate it, until it goes to a sheriff's sale, you are technically still the owner, and you're on the hook for any association fee from the date of your bankruptcy filing until you're no longer the owner. But once again, associations are not likely to chase you. They have the right to, they could, but there's very few firms out there that represent associations that are pursuing homeowners who have vacated and surrendered their condos.
So if I waited until after I was foreclosed and the property was sold and then filed my bankruptcy, then that would be that.
Then you are in the clear. That would probably be the best advice. But not everybody wants to wait that year.
Sure.
They want to get on with their fresh start. They want to stop other creditors from pursuing them.
It's interesting to note, though, that associations can institute a forcible entry and detainer, which is essentially an eviction, to pay your delinquent association fees.
Yes, unfortunately, I've had a client in the past who owned a home, but yet was evicted from the home. And the way we handle that is we try and work out some form of payment plan to get back in good standing with the association so that the homeowner could actually come back and occupy his home. But until he can do that, he will be outside of his own home, despite the fact that he has an ownership interest, because you're right, the association, much like a landlord, has evicted that person for not paying association fees. So when in doubt, if it's between the mortgage and the association, who are you going to pay? You can't afford to pay both.
The association.
You pay the association, you worry about the mortgage later.
And
because the mortgage has to foreclose,
Right.
which takes a year. Association, 3 to 4 weeks.
One more interesting caveat to that. There's a case that just came down from the Illinois Supreme Court involving a lawyer who was part of an association, and he received a speeding ticket. Basically, the association had hired some people who were not trained but were dressed up like cops and who had a car that had amber and blue lights. He was pulled over. He sued because he didn't think that it was appropriate against public policy, all that, and it came down that, yes, indeed, if you are a member of that association, they can enforce the rules against the people who live there, who have agreed to that. Now, the question comes up is, I think it's a tragic mistake, because I could just see a whole bunch of, they could now set up roadblocks and write different kind of rules and do all kinds of things. However, how are they going to distinguish between who lives there and who doesn't?
Well, they might have a pass that has to be displayed in the vehicle
Do you think
or on
that's-
your body.
You think that's going to make a difference of them stopping? Anyway, just food for thought. So just a caveat for people to kind of keep in the back of their mind for our wonderful world of laws.
Yeah, it's interesting. We've got Amy from Blue Island. Can I get on a payment plan to file bankruptcy, or do I need to pay you all at once?
Well, Amy, you can get on a payment plan if you're looking at a Chapter 13. Again, generally it's the filing fee plus a little bit down toward the total fee, which is going to be included. Most of the bulk of it's going to be included in the bankruptcy. If it's a Chapter 7, you can get started with as little as $100 down and make payments. However, again, and we talked about that earlier, generally not going to file it until after you have paid in full. So unless you don't have any urgencies, which are garnishments or repossessions or things of that nature, then you're going to have the time to do it. But again, if not, you're going to have to perhaps, get it from your parents or get it from somewhere in order to be able to make that happen.
What are the pre-filing requirements that one has to undertake before a case can be officially filed with the court?
Well, there is a debt a creditor course that you have to take. It's going to cost you $50, and you can take it online or in person or on the phone. And it's a precursor. You can't file the bankruptcy petition until after you have taken that course.
See, I got some good news for you. The dollar amounts are going down on the classes. It's approximately $15 now.
From 50?
Through several companies. $15. So it's not really a burden to pay the $15 and get that credit counseling done. There shouldn't be anything holding back.
Yeah. Well, you're not in the situation you are because you didn't take a credit counseling class.
True. What are the other requirements before you can file?
After you file that, again, you have to file your certificate of completion of that. You also have to make sure if you have property, you have to make sure, we give you a whole list of homework that you have to do. You have to pay your filing fee.
Okay.
And
but this is all doable. You'll help with the process,
right,
and walk somebody through.
Yeah.
Because that's what it is. People just don't know how the process works. It's obviously not something they do all the time. Hopefully it's a one-time in a lifetime, if ever, event where they need to straighten out their finances and get back above water. So they need a lot of comfort. They need a lot of understanding. I get clients who talk to other lawyers and they feel like they've been talked down to, and they're not getting their questions answered, and they feel like they're a burden to the law firm. And in reality, the clients are the life of the business. So attorneys should do whatever they can to make them feel comfortable with this process, especially since they stand in a greater position of being able to work in that field on a day-to-day basis. They understand what's happening and what to expect, and they need to provide that to their client for a comfort level.
There are all different kinds of people in every different type of profession, but you have to understand that the folks at home are no different than you or me, and no different than the judges, no different than the people on the Supreme Court. The difference is our background and our training. And even if you look at Justice Scalia, hey, is he an intelligent man? Absolutely. Does he have a lot of skills, a lot of experience? Absolutely. Is he better than you or me or one of our clients? No. Okay, we have different lots in this life that we're given, and we need and we ought to treat people with the same amount of respect that we would like to be treated with. And you know what? I mean, just because we're in our profession, again, doesn't make me better than you. It just means that I have different education.
Right. Do you have judicial aspirations?
No, not really. I mean, there's a lot of, it would seem to be a good idea at some point, but I will tell you what, I don't want to be involved with the political rigmarole, and I just would love to continue to practice law and to continue to help clients. That's not to say that judges don't help people. It's just to say it's a different aspect of the legal system.
Yeah, well, it's a shame, because I think you'd make a fine jurist.
I appreciate that, Dave.
I think you'd be fair, and I think you would follow the law, which is most important.
Yeah, we have, again, in every profession, a little different. To whom much is given, much is required, Dave.
Okay. If viewers have questions, they can get us at questions@legalactiontv.com. That's questions@legalactiontv.com. Or they could also just visit the website, legalactiontv.com. And Jesse, it's been a pleasure sitting with you again today. I think we answered a lot of questions about debt relief. These are really tough times out there, so I want to caution everybody to do whatever you can to keep your head above water. And if you have any questions, give us a call. We'll see you next time on Legal Action. Take care. Bye-bye.